Hi everyone, we're going to give it a few seconds to let everyone flow in and then we'll begin. Hello and welcome to our IP for Startups, a monthly series webinar. Today's webinar is brought to you by the SBDC at UCI Beal Applied Innovation in partnership with Troutman Pepper. The SBDC is funded in part by the U.S. Small Business Administration and the state of California. The SBDC is here to help you start, grow, and succeed in your business by providing no-cost expert consulting and training such as this webinar. In addition to our regular consulting on business management and equity funding, we also have been helping our small business clients understand and apply for SBA loans such as EIDL and PPP. We also advise on how to administer these loans if you receive them. If you would like to reach out for any assistance, you can call our number at 1-800-616-7232. If you're a tech or life science business, you can go straight to our intake form at sbdctech.org/contact. All this information will be put into the chat feature. A little housekeeping before we begin. Everyone is muted during the webinar. Tomorrow, the recorded webinar and a PDF copy of the slides will be sent to all participants. There'll be Q&A at the end of the presentation, but please feel free to ask questions during the webinar by clicking on the Q&A box at the bottom of your screen. We may not get to everyone's questions, but we will do our best. If we don't get to your questions, I will provide an email in the chat box that you can send your questions to. Our program today will be presented by Christopher Franish, IP attorney at Troutman Pepper. Christopher represents clients including solo investors, startups, technology transfer offices, and Fortune 500 companies in developing and implementing cohesive intellectual property strategies in proceeding before the USPTO and the PTAB and federal courts. Chris, thank you so much for being here today. I will now turn the program over to you.
Thanks, Hannah. Welcome everybody. Thanks for taking time out of your day. I know a lot of us are working from home these days. I myself am home. Strange time, but the IP issues have remained hot and heavy for a lot of the clients that I work with. A little bit of background for me. I'm an 8th-year associate at Troutman Pepper. We recently merged with Pepper Hamilton. Troutman Sanders did. Been doing pretty much hard tech the whole time, patent prosecution, transactions, licenses, enforcement, like that. A lot of startup work here in Southern California, so I'm familiar with a lot of the problems that you folks face on a daily basis. So today we're going to be getting into certain high-level topics. Right, the intent of this 12-month, this year-long webinar is we're going to kind of start at a high level and we're going to build into the granular. So today it's just kind of a real brief overview. We're going to emphasize a lot of patent-specific stuff. But we will touch on all of the various IP rights that startups should consider at various stages. So those include intellectual property rights, understanding the distinction between patents versus trade secrets, patentability, let's see here, patentability and the patent process generally. So let's get into it. So intellectual property rights. Intellectual property rights, these are exclusionary rights. They allow you to prevent third parties from taking unauthorized advantage of things like the names of your brand, your product. Perhaps you have a patent over an invention, the design, the look and feel of your product, things that you or your company might make, write, or produce. And why? Because these things are what provide you a competitive advantage. So folks use your goods. That's why you are developing the tech that you hope to sell or bring to market. And it allows you to distinguish over your competition. So here's a table, puts together all the various, under the umbrella of intellectual property rights. We have patents, we have trade secrets, we have copyrights, designs, and trademarks. So let's get into it. So what are patents? Patents, they last for approximately 20 years from filing typically. they cover the invention. These things can include features of products, methods, manufacture, materials, compositions. It could be that cure to COVID. It could be how to use the cure to COVID for the different patients that might need, kind of a variant. So you see a lot of this. It takes a lot of investment to bring these sorts of products to market, sometimes years, 10 years, 15 years. And so in return for that, we give you a quasi-monopoly, a limited monopoly, and it lasts for a certain period of time. The protection is absolute insofar as what is recited in your claims. We'll get into what the claims are at the back of the patent application. That's basically what a patent is. And then a trade secret. In contrast, trade secrets are very attractive. Every company has protectable trade secrets. The duration of a trade secret can be infinite. It can last as long as you can make sure that that information remains confidential. And what does it protect you from? Misappropriation. It protects you against someone from stealing your trade secret. And we think of trade secrets as being business strategies, innovation plans, engineering drawings, customer lists, manufacturing processes, these sorts of things where the general public may know that you're selling a product, they may know that you're developing or you're going about it in a certain way, but they don't exactly know your secret sauce, how you're going about doing all those. So the next piece of IP that should be considered is copyright. Copyrights, we think of copyrights typically in the context of photographs, guides, research papers, university level, I think of them as journal publications, but it could be an instruction manual, the layout of your website, things that are creative expressions. They last basically the life of the copyright holder and then another 70 years after death. And we think of it as expression of the idea rather than the idea itself. Because the idea itself we think of as being covered by patent, but the expression might be, the artistic in a tangible medium. That's a copyright. So next on our list here is designs. Designs are attractive because they provide a quasi-patent right, but it's only adds to the ornamental look and feel of a product or the graphical user interface on an app. A lot of tech companies that may be reluctant to invest, say, in the utility patent of software or diagnostic, you can get coverage over a graphical user interface. That's something that people don't typically think of. But in recent years, design become attractive in the context of, like, you might recall the Apple versus Samsung case where Apple had procured a number of patents on the look and feel of the iPhone. A lot of litigation, a lot of years later, it turns out that design patents are quite valuable. A basis to sue, a basis to recur licensing fees. So they last typically 15, 25 years. In the US, 15 years. Outside the US could be up to 25 years. You renew and are continuing to maintain good standing of that right. Like I said, it's the tangible sort of things as we think of it. You might have an instrumentation, instrument tray, a tray, something like that. I have a cup here. This cup, if you've never seen something exactly like this mug, it might protect, you might be able to get a design patent on like the handle, the color, if you want to get a color of it and no one's ever done a red cup, those sorts of things. The threshold is quite low. It really needs to be something that's dead on and exact. And if you can't find that, then you can probably get a design patent on it. And then last but not least, trademarks. So trademarks, the protection of a trademark can be infinite. It can last as long as you're using it. It's kind of a use it or you lose it sort of right. We think of this in the context of protecting brand name, the product name, a slogan, even a logo. And again, the protection is absolute as to if you have the registration, the identified class that you have, how you describe it. So, Coca-Cola I've listed here. Coca-Cola probably has a ton of trademarks, but they almost certainly have it over a beverage. So I couldn't go out and get something similar to Coca-Cola in that space and call it, food, because it would be too close. And then they're using the mark, obviously. Google has their trademarks probably over software and, websites, search engines, those sorts of things. But really, this is a consideration for a startup. If you haven't secured the trademark of your company or products that your company is developing, it's imperative that you think about it right now, because if you have a problem, if there's somebody with a similar name in the space or the same name in the space, then you need to think about rebranding or resolving that potential issue before it becomes too big, because it's a lot more expensive to fix trademark problems after the fact than it is to just secure the trademark registration initially, and then you're good and you can move on to other things. Let's see here. Next slide. So patents versus trade secrets. So on the left-hand side here, I have an overview of, you have a company, they're manufacturing something, you see a bunch of trays, you see kind of a map that, the employees are going between different bins, writing down certain things. And theoretically, you could get a patent on that very detailed process. Would you want to? Maybe not. And the reason you might not want to is because there probably is something unique as to how your company is doing this. And so more often than not, you might think of this as something being protectable by trade secret. You want to make sure you have agreements in place that ensure your employees or independent contractors, folks, they know what you consider as confidential, your manufacturing process, that they sign agreements that make them aware of that. Whereas the product that might result from this process, right here, this bone screw sort of product, that would definitely be protectable by a patent. Maybe a design patent on that ornamental, the curves, maybe a utility patent on how it's used, maybe a utility patent on all the structural features. But this is kind of, I think, of a clear dividing line. These internal processes that may not ever become public, those are squarely in the crosshairs for trade secrets. So trade secrets, they only remain a right so long as it's a secret, so long as it's confidential. And we think of it as formulas, algorithms, your software program, maybe how you track projects internally, customer lists, anything that you think is unique to your company that may not ever see the light of day. That's a trade secret. And these are important because they give you as a company an advantage. The competitors would never actually know it, but you got to make sure that it remains a secret. Again, you're only protected from misappropriation. You can't actively enforce this because you think another company is doing something very similar to your trade secret. They would actually have had to have hired somebody, and you have some sort of fact pattern that suggests that there's something awry. Somebody that independently discovers, you have the classic case right now is, was it Waymo versus Uber? They're doing those self-driving, and it turns out one of the companies had hired an engineer from another company. Let me see a comment. Malik, I'll answer your question when we get to the patent section. It's a good question. So trade secrets, so I was talking about the Waymo versus Uber, and it turns out that I think it was Uber had hired the engineer from Google, and he gave all the trade secrets, and they were able to prove that he had taken the information and that he had signed agreements that he knew that the information was confidential, and in turn they got rights to what they ultimately got patents over, and they were able to get pretty big money damages as a result. So it only covers what is secret. And if it's publicly known or if people independently develop your technology, then of course it's no longer a trade secret. So the name of the game here is you want to make sure that you have agreements in place as early as possible that have ironclad provisions, broad definitions of what is confidential, what is your technology, and make sure you have assignment provisions in here, and just making sure you're buttoning up all of these agreements. It doesn't take that much, but if you don't do it, it can be very costly later. Make sure you're doing this with outside vendors, independent contractors, these sorts of third parties. So what is the difference between a utility patent and a trade secret? Well, you have to publicly disclose information in return for your limited exclusivity period for a patent, whereas trade secrets, you never want to disclose. You want to keep it secret, and they can go on forever if you can make sure that that information remains secret. Utility patents are, they can be pretty expensive to obtain and even more so to enforce. Whereas, it's a little bit of cost up front on the trade secret side. You have to just put a few agreements in place, make sure the language is broad, it is all encompassing. And other than that, there's no sort of forward-looking fees. There's no attorney fees. You would only really consult legal counsel if you thought you had a claim, or you thought that somebody, an exiting employee or a vendor had come in, taken your customer list, and was now using that customer list, that sort of thing. Utility patents are very clear. You have the claims at the back. They recite what is the invention, and that's what the world is on notice to stop. Whereas nobody knows that you have a trade secret over your trade secret. And all you have to do is take reasonable steps to preserve its secrecy. But you kind of have to prove that it exists if you ever did actually litigate it. So again, ironclad agreements and making sure that everybody knows these are top secret projects and these are confidential, all that, and you should be good. The reason you get a utility patent at the end of the day is to also exclude others, but it provides value to the business. You can put it on a term sheet. You can attract investors. You can license it to manufacturers who might want to help you bring your product to market. License it to other companies to sell, that sort of thing. Whereas trade secrets, you can't really license. You can't really add value. You can't tell investors that they exist because it's your secret sauce. So that's really fast. People spend their whole careers only working on trade secrets or only working on patents. So you could get a lot more into the weeds on it, but that's the gist of it. So again, what is a patent? It is a right in return for a disclosure. You get a limited monopoly, and in theory, this is supposed to inspire innovation. In practice, that may not always be the case, but this is the whole reason you have the patent system, both in the U.S. and outside the U.S., is so that people are incentivized to get that limited monopoly in return for telling the world about your technical improvement. So you can file for patents really anywhere. The U.S., obviously, these are just kind of example patent offices here that you typically might file in. But what's important to consider is your U.S. patent is only good insofar as U.S. territory. It doesn't extend to Europe or Japan or Australia. So because this is such a big investment, typically for companies, you need to really, before you even file the application, kind of have a general idea. What is the commercial strategy? Am I just developing this to sell it? If I'm just developing to sell it, where's the market? Where do you want to manufacture? Where do you think someone might knock you off? All those sorts of things. What might be attractive to an investor in this space? Is it only the U.S. market because of something that's only U.S. centric? Is it only China? You got to think about all these things because if you don't, like for instance, if you're a tech company in Southern California and you want to drum up an interest, you want to talk to people, so you start showing some beta samples you might have developed. You show them to a few people, you have a bit of interest, and 6 months later you say, hey, okay, I think I've got this. I think I'm going to file a patent. Well, if you've been doing that for 6 months, you probably can't get the right in Europe anymore. You probably can't get it in China or Japan because they don't have grace periods. In the US, you still theoretically could if nobody's filed in the meantime. But patents are very forward-looking. They're hard to look back, right? So think about this very early in the stage. Where do you intend to commercialize? What's the business plan for this technology? And then from there, file a provisional application before you tell anybody about it. And then, buy yourself some time. So these are the three types of US patents. You have a utility patent, right? You have some sort of a machine here on the left of the screen. You have a design here in the middle. Now designs are all patents are kind of hard to read, but designs in particular, you can see here my cursor is on the solid line. So I know, because I've read design patents, that anything with solid lines or shading, that's what the design is intended to cover. Whereas these dashed lines or these dot dash lines, that's typically for environment. So it's just background, but it's not the granted design. So this right here would cover probably a keyboard with a key, not necessarily G, but just a key in this shape. So that's pretty broad. And then you also have plant patents. These are really uncommon. You still could file. I don't expect anyone on the call to be in the business of developing new plants. There's been some movement in recent years with the opening of the cannabis market on this, but even so, we'll get into. There's some complications with that too, but you know, you can get a patent over a plant if you have a new species. So what can be patented in a utility patent? Anything that's new, non-obvious, and useful. All these thresholds, they vary. Non-obvious is really where the rubber meets the road, but a new process, a machine, an article of manufacture, or a composition of matter. Or more importantly, which is more often the case, an improvement of one of these things. Because, you know, people have been inventing things since there have been people, but the improvements are really what as humans we do well with. We see things, we see problems, and we solve them. And in return for the patent, you have to disclose all this to the public so that the public can understand how to practice your invention. So I know in Southern California, a lot of the startups I work with, they are in the life science space, software as well. In the last 10 to 15 years, the area of the law as it relates to what is statutorily available as patentable subject matter has evolved. So we think of laws of nature, you know, like Newton's law, natural phenomena, abstract ideas, naturally occurring sort of things, or when we think of abstract, something that's just so broad, just let's say you got a patent on software, just software generally, that's too broad, that's too abstract. Anything that gets into these areas, going to get a lot of pushback at the patent office and a lot of pushback if you ever tried to enforce it. When I say pushback, I mean it's just going to cost more, it's going to take longer. And anything that goes towards one of these three, then you're gonna have a problem. So as I counsel startups, and if any of you, if this kind of jumps off the page, if you're in any of these kind of subject areas, then this requires a lot more diligence before you would actually decide to even proceed to file. And so subject matter like this is genes, naturally occurring nucleic acids, proteins, peptides, antibiotics, toxins, organisms. Those are all very life science centric, but even diagnostic claims, you know, diagnostic as to gene mutations, detecting levels, could even be, you know, a COVID diagnostic test. You'd be surprised. Now, the more specific you make your diagnostic, the less abstract it becomes, but the more broad it becomes, then we get concerned with something being abstract and potentially not patentable. If you're in this area, this is probably a time, if you have some sort of invention you're thinking about protecting, you should talk to the legal counsel before you get too far into the weeds, so that you're writing the applications and you're framing your R&D in a certain way. So there are a lot of myths in the patent world. Here's a very, the first myth. My patent gives me the right to make, use, and sell the invention. And so that's not necessarily the case. It's an exclusionary right? So you can tell someone to knock it off. You can enforce them. You could sue them in court. You can do a takedown request at Amazon, send them a letter, all that stuff. But you may not necessarily be able to practice it. We go back to this slide. It's useful. You might have a patent on the improved machine, but it may be that you need the machine itself to operate your improved machine. And if you don't have a patent on the machine and, Acme company has the patent on the machine, then you couldn't use your improvement theoretically. However, the Acme company with their patent, they also couldn't use it because you have the patent. So, you just creates leverage opportunities in the industry. Perhaps you want to cross license. Maybe you want to sell this to a bigger company so they can have a competitive advantage, those sorts of things. All right, so I see a few questions from Malik. Maybe a good time to talk about them. So the first question here is let me see here. How can we determine if this is something unique or something done before? So typically you might want to do a clearance search, prior art search, those sorts of things. You can do them yourself. There's a lot of publicly available patent databases. Even just a general web search on your favorite search engine should bear some fruit. You also, I would assume, as being part of a startup, are quite aware of what others have done in the space. The short answer is there is no absolute way to know, because unfortunately a lot of if you're filing patents, they don't become public for a year and a half. So if you haven't found anything, you think you have a clean bill of health, you think your technology is very disruptive, pioneering, all that, you file the application. It could be that something was filed in the intervening 18 months and you won't find out about it for a long time. But typically it's a prior art search, an informal search, and then proceed from there. So then Malik has a follow-up question here. He says, if this is the case, how do you overcome a limitation? Let's say you find something that may be close. Well, the way that you would overcome the limitation is you would write your application, your patent application, in such a way that kind of lays pretty clearly what the state of the art is and why structurally or why your unique feature was not available in the art. It could be that the prior art was just done a certain way. Let's say you have an EpiPen and you have some unique locking mechanism on the actuator. It could be that the prior art doesn't have that actuator at all. It had a completely different one. So there would be no reason for them to use your locking mechanism. And you would want to think through those sorts of arguments and those things and make sure that they are in patent application. So Eric poses, let's go back to the next slide here. So Eric, thank you for your question. Let me go. So here we have the statutory subject matter, and Eric raises the question on the diagnostic issue. So let's say you have a patent on the detection of gene X. That may be unpatentable, but what about detection of gene X for the purpose of diagnosing a certain disease or for applying for a particular therapy? And that is, now you're in the right direction. Detection of gene X, I would say probably you're gonna get a lot of pushback, but it doesn't hurt to file claims on that and just have support for those kind of secondary, for the purpose of treating a certain disease or for a particular therapy. You can certainly get a claim on that. The famous case is the BRCA diagnostic for breast cancer. The more narrow you make it, certain class of patients, certain very specific subset of the disease, not the entire disease, but perhaps a strain of it. That now you're getting in the sweet spot of you're probably going to be able to get something on the patent because you have not procured the abstract idea. Now you're on a subset of the abstract. You've narrowed it. All right, we'll get to Malik. I'll get to all the follow-up questions here as we keep going. So we did that. So here's myth number 2. Merely having a patent will stop others from copying my patented product. And that's not true at all. These are self-policing rights. Patent rights and all IP rights generally, they are exclusionary. We think of it as a ticket to court. It doesn't have to be a ticket to court. If you have a trademark registration or design or utility, if you have a product that listed on like an eBay or Amazon, they have informal ways to take down those products if you can identify a patent, a trademark, and that's usually pretty easy. But otherwise, you'd have to do the old write some demand letters or go to court, put together a complaint. And that can get expensive. But the fear of liability may stop some competitors because, again, it's very expensive. It's very complicated, can take a long time to resolve. And most companies want to shy from that. Not all, but obviously a lot do. Let's see here. So let's work through patentability. Again, we're just going to move through these at a very, very high level. So there's 4 basic statutory things that need to be in your patent application for you to get a granted patent. Needs to be useful. I've never seen a rejection on whether there is a lack of utility. Needs to be new, and this is more on something can't be completely the same as yours. Even just one slight variation should be enough for novelty, and it also can't have been publicly available for more than 12 months. So this goes back to that fact pattern where you might have some widget you've developed. Well, don't go telling the world about it for 12 months and then try to file an application, because now you've become your own prior art. The rubber meets the road again on obviousness. Usually there's been something similar to you in the space. Maybe not too similar, but I've seen obviousness refusals where it's like 5 or 6 or 7 references, sometimes more. And that I think if I see that you'll probably get a patent, but you're probably going to have to argue a little bit. But it's not always that complicated. If it's just, different enough, you should be able to get a patent. And every technology is different. So how different you have to be depends. And then finally, your application has to sufficiently detail. It has to be enabling to someone of ordinary skill in the art to bring the technology to market if they wanted to, kind of use your application as a quasi blueprint. So what are the substantive parts of a patent? So I keep saying claims, but at the back of the application is the most important part. It's the claims. This is what we think of as demarcating the invention, the fence around your property, the property being on the inside. So you have a series of claims at the back. They're written in a certain way. You're going to have, if it's not like a composition, if it's something that's tangible, like here we have a clot capturing device, you're going to have probably a few figures, and then you're going to have to describe those figures and the basic technology in the specification. So again, you have to write your claims to meet all those prior statutory requirements: utility, novelty, non-obvious. And you have to write the specification to meet the disclosure requirements. So the claims define what is the invention. The whole purpose of the application is to support what you write in your claims. And the claims, you got to strip out all the fluff. You want the essential elements only. It could be, a widget with 3 features, and that's it. They should be kind of interconnected how they operate, but otherwise, it's kind of an art form how you write them. They're hard to read once you get a handle on all the buzzwords. It's pretty straightforward. So here, I thought it might be useful to kind of walk through a very high-level claims writing exercise. So claim 1, we see device. It's the system. You might have your widget. And so here's our claim 1. This is our Venn diagram. And then we have the dependent claim. So it's kind of a narrower version. You're going to add a feature that narrows its scope. So this is claim 2. It's less of the overarching circle. And then we have an independent method for making the device. So now we have claim 3, and you can see now we have a little bit of overlap, right? It's talking about the same device, but the method of making it is a bit different. And then a method of using the device. Perhaps it's a medical device, so you're going to be using it to treat patients. And we see, now we have a nice clean Venn diagram. We have different scope. And this, you could think of kind of the solid line here on the outside as being the fence around your property. Anybody who gets on your property here, they've trespassed, they've infringed. Anybody who's on the outside, they're free and clear, they're fine. And so on the question previously raised, how do you get around art? How do you think about these things if there's something similar? So here's a close-up on the figure of your clot capturing device. There's a ton of clot capturing devices people have been trying to use expandable stents for some time, probably about 20, 25 years. So you see a catheter on the right, a little guide tube. So here's, it's a pretty picture claim. You see all these numeric elements right here, and all of the elements are called out. Here's our claim one, right? So we know in black here is the prior art, and red might be some patent that we really want to avoid because, some big pharma company owns the patent and they're litigious. So we want to avoid them, core invention. But we don't want to just be so narrow. So what if we strike out this feature right here? Because we don't think we need it. You can see our claims code, it gets a little broader. And then we want to also take out this limitation because maybe we don't need to have this inverted configuration. It's not necessary for the patent. Now we can see that we've gotten the scope of our patent has gotten so big that now we overlap with the prior art. So this goes back to your question, how do you plan for the prior art? You have all these features. The narrower the claim, you avoid the art. The broader the claim, now you have a problem. Maybe you are now, this isn't your product. Maybe your product itself embodies all these features. And if it does, then you need to pause and think about if you have any sort of freedom to operate problems aside from whether you can get a patent. But this is kind of this give and take, this, give a few features, narrow the scope, get the patent, or broaden out. So here's a simplified timeline of the whole process, right? A lot of times startups might just put every feature of the crown jewel technology in a provisional application, then go shop the technology, talk to a manufacturer, talk to some partners. In the intervening, you have 12 months to convert. You might, maybe if it's a medical device or it's some software that improves the computing power, so you could show, look how much faster we are diagnosing people, we are removing these labs from the process, or if you can show any sort of objective improvement via data, maybe you should file some intervening provisionals. But in the meantime, 12 months, you need to think about critically, is it worth the investment in converting this? Is it realistic? I'm going to get the patent on this. What's the state of the art? Where am I going to convert? File the non-provisional application, and then you get examined 1 to 5 years later. Hopefully, you get a grant. Outside the United States, there's an opposition period in some countries. It's really country specific, so I won't get too far into that, other than the fact that there can be an opposition period, which is basically people can challenge whether you should have a patent. So what is your company's role in the process? So this goes back to kind of preparing, both making sure your trade secrets are protected with agreements, making sure you have ironclad provisions in place, but also avoid telling the world about your inventions, your tech, unless you have to, because we don't want to create our own prior art. You don't want to shop your technology around, look for investors, potential new hires, and for something that could be deemed a public disclosure. Because if it's too public, if it's been public for too long, more than a year, you're not going to get the patent because you have to tell the patent office about it. Patentability, anything that's new, non-obvious, all that. And then the actual kind of nuts and bolts of writing up these applications, you should be involved in the process as soon as you practically can. Why? Because you are the experts, and any sort of patent agent or patent attorney that you work with, they're not going to know your technology as well as you are. There might be a lot of assumptions built into your figures or how buzzwords that you might use, and we just may not know it. So the earlier you kind of get engaged in the process, the better it makes for a more succinct, tighter application, possibly cheaper. You can shave some cost on that, and the better patent that you have in the end to enforce or license and what have you. So another strong consideration for startups is kind of institutionalize the whole process, because you might have some tech internally that you're developing, but you may not realize that you can get a patent on it, and you may not realize that an investor who might want to write you a check to invest in the company might actually find value in some ideas that may not be directly related to the core concepts, the core tech of the company. So let's institutionalize the invention process. A lot of the larger companies I work with, they have patent review boards. They might be meeting monthly, quarterly, but as soon as somebody has an idea, they try to write it down, date and time it, who they spoke with, create a record, and then whatever works best for your company. But try to get something on calendar, because it's easy to avoid these conversations. But if you don't have them, then you won't be able to realize that you have something that could potentially be patentable and add real value to the company. So, form the idea, create a record. You can put together some patent disclosure forms. It's very common for companies to develop forms for their company because their tech might be unique. Have this review where everybody can talk about both whether it's new enough, is there any sort of real opportunity to reap a return on this? How are we going to commercialize it? Or are we just going to get the patent and then sell it to somebody or license it to somebody? Is there licensing revenue available? And if you tick all the boxes and you got the warm and fuzzies, then move forward with writing up an application. You can do as much as you can internally. I would stress, if you're going to make it this far to write up the application, you should use outside counsel, an attorney, an agent, or hire somebody if you think you're going to be filing so many. Make them work in house. File the application, and then the application can be pending for a few years. You can expedite it, so it can be shorter, or it might be pending longer depending on the tech. And then you get the patent. So what should be on your invention disclosure form? At a bare minimum, who the inventor is. If you can't identify the inventor, then you should pause, because that can sandbag the entire patent itself. You need to be accurate on who the inventor is. And how do we define who an inventor is? Well, once you've written up the claims, you do a claim by claim analysis. And you might say Steve contributed to the first 3 invention elements, and then Sue worked on the last 4, and then these 3 people work together collectively on the whole system. So maybe all of those people should be listed as inventors. Sometimes you don't have to have that. Maybe it's just very clear that it was a group effort and everybody should be listed, or maybe not. And if it's not, then you should have that more detailed conversation. And then we've talked about novelty and non-obvious, all that. In the form, I've found that it's quite helpful if you can articulate clearly what is the problem and what's the solution, because that's really how we frame the claims, because we want to attack the essence of the invention. And if we can frame what the problem is, then you can also frame how others before you might have attacked that same technical problem. And this all works towards clarifying the technology. That's more in the drafting side. So here's the typical kind of life cycle of a patent application. You might file the provisional. It's a 12-month placeholder. File the non-provisional, get the grant. You might also, if you're thinking about filing overseas, or maybe you want to do business with a Japanese company or manufacture in China, the most cost-effective way to do that, file a PCT application. It's a way to preserve your international rights. You still would have to ultimately file, but kicks the can for about 1.5 years or 30 months. Or conversely, if you're only going to stay in the US and maybe do something in Canada, then maybe you just bypass all that and just file the US and Canada. Everybody's market's different, and the more that you can provide on your market, the better informed you can be when you make your decision as to how to file. So another thing that may not be completely clear, a lot of startups just throw the kitchen sink in their provisional applications. You may have 5 distinct inventions, and then when you file in the US or overseas, you might get a restriction which makes you have to choose only one of those 5 inventions. The long-term strategy might be that you want to get a patent on each one of those inventions, and this is just kind of a schematic here to tell you that option always exists. And often companies do this. They build out the family. I have a divisional over here on the widget with a blue cap, and then the con family on the red cap. You can come up with any sort of mix and match of features, and every tech is different, but this is just a strategy that some companies. So why go through all of this, right? At the end of the day, startups are trying to bring technologies to market. They're trying to develop, they're trying to disrupt fields. It costs a lot of money right here, right? Most startups don't have many resources at the beginning. So you have to be very selective. You're on a shoestring budget. The investment here, it's a lot, but the point is once you start getting funded or you notice people are knocking off or there's licensing opportunities, that in the long run, the return is a no-brainer, right? It doesn't cost much to maintain the patent after you've got it. You don't have to deal with the patent office other than maintain it every few years. And the tech could have enough value. You could sell to somebody and you get that return back, at least the return on the cost to do it, if not more. And you also prevent others from getting coverage over the exact same invention. And sometimes there's value in that too. So I see I've got a bunch of questions. So I will go through the outstanding questions that we have here. So let's see. How do you start the patent application and how much does it cost? From the leak here. How do you start the patent application? So I kind of walked through that, but the easiest way is you might do an informal search, a patent search. You might hire somebody to do a search. You might just do it yourself. And put together the idea in a form, in an invention disclosure form, or just write it up. Make sure you have some figures, some claims, understand exactly what others have done in the area, and why you are different. If you just farmed this all out to an outside a patent person, I mean, it's hard to say how much it costs because technologies are very different, right? You could file a design patent for around $1,000, $2,000, depends on what the technology is and how many figures you have. A utility patent, I always think of them as generally costing about $10,000, but not every application is the same. You might be talking to an investor today and merely have a slide deck and you just need to get something on file. Well, that wouldn't cost much, $1,000, $500, but you would at some point have to spend the time or the money to draft up a real application. And if it's a real simple invention, maybe it's like, $4,000 or $5,000. If it's very complex, it's a composition, it's going to take a lot of time. Maybe it's 20,000, but again, it varies. So Hamesh asks, how do you defend against infringement? So how you defend against infringement, Hamesh, good question. I assume you're talking about patent infringement. So if you're defending against patent infringement, it's one of two ways. Non-infringement, you identify features of the claimed invention that your technology does not practice. And you either do that in court, that's a lot more costly in court, or if the patent holder has done you the service of contacting you before they file suit, then you would deal with this in like letters or conversations, phone calls. More often than not, they don't agree. But if it is very clear, it's very black and white, then that should be enough. If it is impossible for you to identify a feature as non-infringing, then you would have to explore kind of invalidating the patent, finding one or more prior art references that render the patent that is being accused of infringing, finding out and making the case, and either again mitigating this informally or being prepared to tell a court why that patent is invalid because it's not new or it's obvious. And that's easier said than done, right? I mean, sometimes that can take 2 or 3 years if it's in court. Sometimes that can just be a simple phone call because again, it's so binary. It's black or white. Warren asks, does business name or doing business as supersede a trademark? The short answer is no. The business name, you might have common law trademark rights. Common law trademark rights, they are not the same as federal trademark registration. They still are rights. They're rights at common law, as we say. But you would essentially have to prove that those rights exist if you ever tried to enforce them. And what's more, you wouldn't be afforded kind of legal damages. It's pretty inexpensive to file a trademark. It's like $275 a class. And the trademark office gets back to you within 3 or 4 months, typically from filing, where they will identify kind of some any sort of roadblocks. If there's another company that has a similar or the same name or product, all that. How does this impact the website address? Well, so if you don't have the trademark registration and someone else has the trademark registration, then they could do a takedown request of your domain. You could be accused of cyber squatting. Hey, this happened, say about a month ago. The Washington Redskins have been in the news for a number of years, or the Washington football team, as they're called now, and a gentleman in DC who was a fan of the team just bought up every domain possible that he could come up with. The Washington Warriors, the Washington presidents, the Washington politicians, all, any sort of which way, and he registered trademarks in all of those. If someone else had registered those trademarks, they could do a takedown request, a URDL complaint, and it's not litigation, it's litigation light. But at the end of it, you get your domain back. Theoretically, could be accused of trademark infringement. So it's very easy to get the trademark. It's harder to unwind the potential issues that can arise if you don't have the trademark. So I recommend always, early and often, get the trademark. Let's see. Mina asks, what are your recommendations in approaching companies discussing my provisional patent? Well, the short answer is, if provisional patent, you're satisfied with what's in it, you can be pretty candid. It's always advisable, because it's not public yet. A provisional is never public. Get them under an NDA so you can speak candidly and make sure that you have control over any IP that might develop even in a single conversation. But otherwise, talk away. The reason you filed the provisional is to cover yourself, right? So that even if you didn't have an NDA, or if the NDA kind of breaks down, that you're covered because you filed the application at the patent office before they did. So you would have essentially won the race. So Eric asks, can supporting data be added during examination? Does it become part of the application and the claims, or is it just for the examiner's reference? So you couldn't add the data in the application per se, but it would become part of the record. So for instance, you might have, let's say you have some drug, and the drug is claimed as treating some disease. Then the examiner might come back and say, hey, you need to prove to me that your drug actually does cure this or treat this disease. And what often happens is you might go back to your PhD, your technical inventor who's in the lab, and since filing your application 2 or 3 years ago, he might actually have a body of data that he submitted to the FDA, or that he has, and you put together an inventor declaration, you get it on file, and you work with the examiner, and the examiner will typically buy it or come back and say, hey, I need you to do this, this, or this. So it wouldn't become part of the application, but it would become part of the record. So if anyone looked at the record, they could see it. Okay, so Ryan asks, all markets being equal, what countries outside the US do you generally recommend companies file in? Are there certain countries to avoid? The typical filing strategy is just basically to develop IP markets. So it's like Japan, Australia, the European Patent Office, which at filing covers all of the EU, including the UK, even post-Brexit. Canada sometimes makes it on this list. I mean, I think of it as places where you have a robust legal system, and where there are norms, they have a body of case law, and there's kind of predictability. A lot of people file in China too. China's a harder one to get into for enforcement. They have a lot of enforcement options, and it's harder. It's more costly sometimes, and less predictable. But those are usually the markets. In terms of avoiding, I don't know. Japan can get pretty costly. All the translation fees that you might incur. But then again, I think of these less as where should you file, and more, well, what is the reality of the market related to your technology, or conversely, what would an investor see as attractive? What market you cornering? Mexico might be your market. South America might be your only market, so you would file there, and you wouldn't file in all these other places. Okay, Anonymous asks, what is the percentage of patent applications granted? This really does depend on the art unit. Every art unit has its own allowance rates. You know, sometimes in the biotech space, it could be as low as 25%. Sometimes in the hard consumer goods space, it could be, you know, close to 100%. But really the question is not whether you'll get a grant, but if you get a grant, how broad are your claims? Because you don't want to get a patent that doesn't help you. You want a patent that covers your product and a product and claims that cover kind of the future looking of the technology, so you can prevent competitors getting too close to you. Those sorts of considerations is what I think. Malik asks, what is the average wait for the result of a software patent? And do you recommend having a lawyer speed up the process or doing it myself? What is the fee if I want to hire one? Okay, so software patents, I hesitate to say, because again, you could have a software patent on a diagnostic, or you could have a software patent on a manufacturing process. I mean, it really does depend on what the underlying tech is, because that's going to put you in your art unit. But I mean, software in and of itself is not going to take any longer than another one, all things being equal. It could take 1 year to, could take 6 years. If it's more kind of biotech-y related, diagnostic, yeah, you could be in for a longer wait. How do you speed it up? You can, there's two really common ways. Prioritized examination, it's where when you file the application, you basically provide search results and a declaration that says you did a search. And that I think might be free, but it's kind of problematic from a prosecution estoppel standpoint. The other one, it's free as to cost, but you may have to pay an outside vendor to do the search. A track one application is a very attractive option. It's $2,000 for a small entity. I don't know if it goes down for a micro. For a large entity, it's $4,000, but you get a patent or final disposition under a year. So if you have an important product you're going to market, this is a very attractive option for people, because you don't loiter at the patent office. I mean, you can identify big issues, you can work through the process, have your. What is the average lawyer fee? I mean, again, I said this earlier in terms of cost. It's hard to say. I always think of patents costing about $10,000 to file. Again, they could be as low as $500 if it's just a bare bones slide deck. It could be, you know, 20,000 if you're talking about, you know, some very complicated composition. How important are trademarks in the IP strategy? Is asked by Manny. Trademarks, they're easy to overlook, but they may be one of the most important pieces, because while the early stage company might have a general idea as to the tech they want to get into, if you have a name pretty well settled, you need to figure out if you are clear to use that name, because if not, it's way easier to change and rebrand before you actually have like goodwill associated with the brand you're selling, selling product or trying to develop product, than it is like, say, 3 or 4 years later. So I always think of it as being quite important. One of the first things a company should do is invest in at least the product name and the company name. Make sure it's secure. Do all that diligence, so you can move on to bigger and better things. Because if you don't do that, it could come back to bite you. Anonymous asks, what does it cost to have an initial consult with you or your company regarding a patent? Free. It's always free. Usually the initial consult's always free. We talk about, whatever your tech is, what the problem is, provide a general strategy, provide a general cost based on whatever facts you provide, and then go from there. Henry asks, how do I license my patent? Yeah, the short answer is there is no easy way. There are websites these days where you can kind of list it. You can contact a company. The easier way is to contact the legal department for a competitor or a big company. After you have filed or procured the patent, you do this. See if there's any interest. It is kind of a DIY. There is no form database. another alternative in this is hedge funds have been getting into patent funding lately in the last 10 years or so, where let's say you got a patent in a space that is very, there's a lot of profit potential, or there's somebody who's knocking off your tech. Let's say Google is knocking off your novel, something related to a website or a search engine, and it's clear as day. It's no question. Then of course you can attack the bare bone value of Google. Yeah, it'd be poking the bear. They would fight tooth and nail, but a hedge fund might see that as attractive because maybe they can get a pretty nice sizable return on that. You see that's another way people think of licenses, figuring out if there's a market either for litigation, or you might just want to sell the tech to a company, have them deal with it. Russ asks, invented records idea. I use a bound spiral notebook, also date as to whatever. Every page is dated in this manner. Do I have to have a witness and sign and date each page? Nope, you don't have to. It helps to make sure you didn't, make it up, you didn't fabricate it, but otherwise you don't have to. There's no duty to do any of this, but this becomes more important if there becomes like a derivative proceeding, or there's a priority date proceeding to show that you were diligent, you conceived of this by a certain date, and you have the records to back it up.
Hey, Chris, looks like we've run out of time. Did you want to keep answering questions, or?
I'll do one more. Let me see if I've done anything similar. Actually, I can bang out these. It's not that bad. Okay, so Evelyn asks, I'll just do all of these, and then after that, Hannah, you can provide, whoever attended, you can provide them my contact information, no big deal. I have an idea on making, Evelyn asks, I have an idea of making real estate affordable, affordability easier with my tech. Can I patent the idea even though the tech part isn't developed yet? So sure, if you have an idea as to how you would develop it. If it's still missing some steps, then you might wait, but then again, maybe file a provisional as you sort out those details to at least ensure you have a filing date. That's what I would do if I was you. Tyra asks, can we still patent a device if we have already received money for the device that we developed? Sounds like you've consummated a sale. I'm not sure, but if you received money for the device, but you did not disclose the device, like if you said you were going to develop a widget that cured COVID, but you didn't tell them how it would cure COVID, what features it would have, then yeah, you could probably still get a patent on that. If you have offered for sale the exact invention, they have seen it and they gave you money, then really all that means is you could get a patent if it wasn't longer than 12 months ago, probably. Anonymous asks, how can you extend a patent? You can't technically extend a patent, but if you have an improvement, that might be one way. If you have a different way of like a different application, you have a drug that's to treat disease A, but now you have you think it could treat disease B, and you have evidence of it, then you could get a patent on the treatment of disease B with the drug. If you are at the FDA and you've accounted for some delays, you can extend the life by up to 5 years, but it has to be kind of related to the FDA's delay. And there might be patent term adjustment based on delays at the patent office. Those are kind of typical ways. And finally, Himesh asks, do you have names for patent litigation funding companies? Yeah. The one that I know off the top of my head is Parabellum. Parabellum's a company in New York, but you really could search patent litigation funding in a search engine, and you should come up with a number of results. Go from there. Yeah, you just basically contact them, call them, send them an email with whatever patent info you have, and they will do their diligence.
Thank you, Christopher. Those are all the questions, and thank you for staying overtime to answer them. We really appreciate it.
No problem. Any other questions? Feel free to reach out. Otherwise, thanks everyone for taking the time.
Thank you, everyone. You'll receive a copy of this tomorrow.
Cool.
Thank you.
Yeah, bye guys.